This is part 4 of civil procedures, looking at motions to dismiss. This is 12B motions. If the motion is for subject matter jurisdiction, this may be brought at any time during the process. If the motion is for personal jurisdiction, venue, service of process, sufficiency of process, these must be brought pre-answer. So if you answer, you waive personal jurisdiction, venue, process, service of process. The effectiveness of that makes sense. If the motion is for failure to state a claim, join a necessary and or indispensable party. This may be raised in any pleading, motion for judgment on the pleadings, or at trial. So subject matter jurisdiction, anytime. Generally anything else, personal jurisdiction, venue, process, service of process must be done pre-answer. State a claim, join necessary indispensable parties, can be brought in any pleading, motion for judgment on the pleadings, or at trial. Looking at denials in your answer, if it's a specific denial, it must be done by paragraph. If it's a general denial, this is denying every allegation in the complaint, that's okay. However, you must intend to controvert all of these allegations. Affirmative defenses in your pleadings. Affirmative defenses are acts and or facts other than those alleged against you, which, if proven, defeats and or mitigates consequences of the defendant's conduct. Now, these must be stated in your pleadings or they are waived, and these include things such as contributory negligence, duress, and or fraud. Looking at joinder of parties. Joinder is the philosophy behind joinder is for efficiency and economy. You have permissive and compulsory joinder. Permissive joinder is where the plaintiffs may join and the defendants may be joined. There must be, to join, there must be a right to relief jointly and or severally arising out of the same transaction and occurrence or series thereof, any common question of law and fact. The same relief need not be demanded. You must meet a federal subject matter jurisdiction requirements to join the plaintiffs or defendants. Compulsory joinder of parties, so you have permissive and compulsory. These are where parties must be joined. Now they must be joined, it's necessary for a just adjudication where complete relief cannot be granted without that party, or the absence of the party may impair them from protecting their interests if they're not joined, or where remaining parties left with a substantial risk of multiple or inconsistent obligations, such as you're being sued by one plaintiff, you get a judgment here, you can also be sued by another plaintiff later for the same transaction or occurrence. Again, here you must meet subject matter jurisdiction requirements. So that's joinder of party. You also have intervention of parties. You have intervention of right, and you have permissive intervention. Intervention of right is where a non-party has an interest in the property and or transaction, and not being part of the action may impair the non-party's interests, and the non-party is not adequately represented in the action. Now, here you may not destroy diversity. So you may have the right to join, but if you did, you would destroy diversity, then you cannot join. Looking at permissive intervention, this is where the movement has a conditional right to intervene. This is under federal statute, or they have a claim and or defense that shares a common question of law and or fact. And again here, it's permissive. You may not destroy diversity either if it is under diversity jurisdiction. Looking at joinder of claims, so we have joinder of parties, intervention of parties, now we have joinder of claims. Joinder of claims, these are permissive joinder. They may join all claims that a plaintiff has against a party. So if you have two claims against a party, you may join those in one action. Here the court must have subject matter jurisdiction. Now, that's not always the case. We recall supplemental jurisdiction from an earlier conversation. Supplemental jurisdiction is, in essence, subject matter jurisdiction. So it doesn't necessarily just have to be federal question or diversity. You can also have supplemental. Looking at counterclaims that are compulsory in joinder of claims. Compulsory counterclaims, you must join all claims that arise out of the same transaction and occurrence. Again, court must have subject matter jurisdiction. So if you get sued, you have to file any counterclaim that arise out of the same transaction or occurrence. Again, the point of this is efficiency and economy. Looking at permissive counterclaims, so that was compulsory, you must join all claims. Permissive counterclaims, these are not compulsory claims. Obviously, they're permissive. You may raise them, but they're not required. Must have independent subject matter jurisdiction. Looking at class actions, this is a single person and or small group that represents all interests of a party. This is where the class is too numerous for joinder. They must have a common question. Members of the class must have a common question of law and or fact. Claims and or defenses of the reps must be typical of the class, and the representatives must fairly and adequately protect the class's interests. And you must meet subject matter jurisdiction, meaning federal question or diversity. In regards to venue, this is based on the representative parties. And that completes Part 4 of Civil Procedures.